So, okay, so we have now that we have the Honorable Special Prosecutor, and I'm going to disable the waiting room so that as many as can enter will enter. Then those who cannot enter, as indicated, we are recording the session. They can play it later on. Okay, so a very good afternoon to all of you. As I notified you that we have a special guest this afternoon, and he's a very experienced teacher, loves students, always working hard for students to get good understanding of the law. And last year, he was with us during the COVID post-lockdown when we were preparing to write the last year, that is 2020 law school entrance examination. And this year too, he's been quite generous despite his busy schedule. Not to talk of the fact that his recent portfolio as the second person to hold the important position of the Special Prosecutor of the Republic of Ghana. He has a lot of things on his table, certainly in a new position and all that. And despite all that, he has offered to help us. So I'm very happy to introduce my learned friend, a mate, and a very good friend and brother, Honorable Special Prosecutor, Kissi Adjebeng. Kissi Adjebeng. You'll notice that when I sent the notice, I made a mistake in how his name was captured. So for quite some time now, he's known as Kissi Adjebeng. So take note of that. So I'd like to welcome Mr. Adjebeng. Honorable Special Prosecutor, you're welcome.
Thank you for having me.
If you don't mind.
And good afternoon to all.
Good afternoon. Maybe your students would like to see your face even for a brief moment. Very well. Okay, wow. Well, that's great. So good to have the Special Prosecutor here. So now, students, as I told you, he is a very experienced lecturer. He's been teaching criminal law, University of Ghana School of Law, Legon, for a very long time. And of course, he's a very a good lawyer and experienced and well knowledgeable in the law. So he's here. He can handle any aspect of the law, but this afternoon, because of his role as special prosecutor and his previous portfolio as a teacher of criminal law, I would like Mr. Adjebeng to lead us in discussing issues of criminal law, which you will need some guidance. So I will hand over to him and he will lead us as he wants, as whether he will give like some brief remarks, and then he will let to raise issues for him to guide, or however Mr. Adjebeng wants to handle us. We are very ready. So, Honorable Special Prosecutor, over to you, Jolati.
Thank you again. So, course of time, you know, criminal law is so expansive and we can't do it all in the time that I have. Indeed, in the next 35 minutes, I would have to step down and go for another meeting. So what I'll do is the latter, which you suggested, that is to say, I will just give a brief intro, and then if there are some concerns in respect of specific areas, can address it, then we can bring the curtains down. So, you know, the entire body of the criminal law is about the determination of the liability or culpability or otherwise of an accused person. So that is what you should have in mind. And in that regard, you're looking for the requirements of criminal liability. That is the foundation of the criminal law. So whichever way a question is put, whichever way it is molded, that is what forms the foundation of the criminal law. And so the requirements of criminal law, they determine the culpability or otherwise of an accused person. And since you're LLB holders, I presume, you would have heard of Actus non facit reum nisi mens citria. That is to say, a person is not guilty of a crime charged unless he has an accompanying guilty mind. So, but I mean, put it crudely that way. These are the requirements of criminal liability. So the physical aspect, which is the prohibited act or the proscribed act, you know, as the Actus reus, be looking for an Actus reus. If you cannot find an Actus reus, then that ends the discussion. Now, the Actus reus can come in so many forms. It could be an act in itself, that is to say what we normally call a positive act, that is a person setting out to do something. It could come in the form of an omission to act. That in itself is also an act. If the law imposes an obligation on you or a duty on a person and the person refuses to act, the refusal itself is an act. It could also come in the form of being something, what we normally call status offenses. You are in the mode of being something. An example is the old common law offense of vagrancy, which is no longer on our books. So if you were a vagrant that is of no known fixed address, then that was inviting criminality. I said it is off our books now. It could also be in another form of a status, that is to say, you also being in a certain state of affairs in the general scheme of things. So an example could be you being in possession of something. You have not actually applied what you are in possession of to do anything, but the mere fact of you being in possession of the thing could found liability for a proscribed act or a prohibited act. Actus reus could also come in the form, disturbingly, of course, in the form of a mental state. That is the awareness of doing something, the knowledge of something, the knowledge about something. Now, mind you, this is not mens rea, which is the mental state of a person. It is akin to mens rea, but in this sense, someone doing something with a certain awareness itself becomes part of the actus reus. And once again, an illustration would be being in possession of something. Because if you are in possession, just being in possession of something without the requisite awareness or knowledge of what is in your possession, the law will not pay any attention. So the awareness, the scienta, the awareness of you being in possession of a prohibited item itself is also a form of actus reus. Now, you know that we cannot just say a person has committed the prohibited act without seeking to establish whether his actions at the end of the day formed the basis of the unhappy event or the unhappy result. And so the actus reus rests on the concept of causation. So if a set of events are spiraled into motion, you are looking to find whether at the end of the day you can trace the ensuing event to have been brought about by the person's actions. Sometimes a person acts alone. Sometimes a person acts together with other persons. Joint causation, that's how we call it. And sometimes it's not necessarily so joint, but each person plays some role in bringing about the ensuing event. But here, that's where you should have it in mind that at the end of the day, we're looking at a person whose act was so present or prevalent in the scheme that taking his act out will render the event not folding, that is unfolding. So if we are to take out your part and the event still ensues, then it suggests to us that your contribution was minimal. And this is what we call the de minimis rule. That is to say, am I still on? Prof, am I still on?
Yes, you are. You are. You are here.
Oh, well, I got a call through, so it looks like I was knocked off there a bit.
Okay.
Right. So yeah, where was I?
You are talking
Okay,
about
so you
minutes. Yeah.
Yeah, the de minimis trivial thing. And so the computation here is a strict analysis of the person's contribution to the ensuing event to determine whether his act was merely part of the history of the event, or that his contribution was an operating cause at the end of the day. So how you do this is simply to go back and consider the person on his own actions. When you do that, then you are reckoning, coming to terms with how to weigh his actions. And stepping back again, it will then mean, as I said earlier, take his act out of the equation. If you take it out and the event is still occurring, it means that his actions were de minimis. That is to say, it is not an operating cause, normally speaking. But if you take out the person's action from the equation and the event does not occur or does not ensue, then that person's action is really the cause that caused it, what we call the causa causans, that is to say, the operating cause. So there are so many, the law has not fully come it has not come to its full realization as to the scenarios that can make up Am I on?
Yes, you are.
Okay, I keep getting calls through. So by and large, what you're looking at is really section 13, clause 7 of Act 29. That is to say, it is a matter of fact whether an event can be fairly and reasonably ascribed to a person's conduct or actions. So it is really a common sense approach that did this person's actions bring about this event? And in Ghana, as far as the mens rea is concerned, you are either causing something negligently or you're causing it intentionally. Now that brings us to the mens rea requirement. So, although we have strict liability offenses, we don't have absolute liability in Ghana. I doubt if there's any jurisdiction with absolute liability. Even where the offense is defined to sort of exclude a mens rea requirement, judges have always read into criminal legislation the requirement of a mental state of mind that will make a person culpable for the offense. And so a mere commission of a prohibited act does not immediately form the basis of culpability unless we go into an excursus of the person's state of mind. Now, as to the person's state of mind, it is only him and his maker who can really tell us what was going on in their minds. And so, since we cannot divide up a person's mind, we don't even know where the mind resides in a person, probably in the brain, but who knows, some people act as if they don't have brains. So, what we do is that we cannot figure out what was on your mind at the time. So the law looks at, and since the law, in this regard, the law always tries to hold its majesty by not being embarrassed. And since it cannot embarrass itself, it will look at more objective indications of what was going on. So you look at the person's act and the surrounding circumstances of the person's actions to come to the conclusion as to the state of mind of the person at the time he committed a prohibited act. So it may coincide factually with what was exactly on the person's mind. But if it doesn't coincide with what exactly was on the person's mind, then too bad for the person, because these are all presumptions that keep us going. And so if you take the commonest form of mens rea, which is intent, that is where that major presumption is erected, that a man intends the natural and probable consequences of his actions. And here, we're looking at that which naturally flows in the human condition, in the human context, in the ordinary circumstances of mankind from a person's actions. If you engage in action A, is it in the normal course of things that result B would ensue or occur? If that is the case, then we will hold you to it unless you are able to show us under 11.3 that that is not what you intended at all. It seems a secutor's way, but that is what we have now, unless you can come up with a better proposition. But that is what we have in the law now. And so it would then tell us that, or it would seem that it is not only when a person sets out to achieve a specific result that the law will hold him culpable for a certain mental state. Sometimes, depending on the person's act and the surrounding circumstances of his actions, the law will hold the person having purpose to bring about a specific result, even though that is not what he set out to achieve at all. And closely linked to the commonest form of intent is negligence. And here is the bane of students. Let me take 2 minutes to talk about this. See, negligence is akin to intention, but they are not the same. Immediately you start talking about intent and you veer into negligence, everyone will see that you're confused and you're marked down. They look so similar, but this is how to distinguish them. Intent is simply a person purposely aiming to achieve a certain result. That is intent. Negligence is where a person does not set out to purposely achieve a certain result, but whilst engaged in the act, he acts without the required skill or care that attends to that action. That is to say, you can put it in a very crude form, as in the person is absent-minded. If you are failing to apply the skill required of you in an act, the care required of you in an act, it doesn't suggest that you are purposely trying to bring about a certain result. That's why some test writers say negligence shouldn't even be reckoned as a form of mens rea, but that is their writing. What we have under 12 and under 51 clearly tell us that negligence is a form of mens rea in Ghana. And then you have unlike in the civil law, you have the gradations of negligence in the criminal law. The ordinary negligence under 12, which has interesting illustrations and permutations, and the gross kind of negligence that is a reckless disregard for human life when you're dealing with involuntary manslaughter under 51. Then the other forms of mens rea, apart from the requirements of criminal liability, there is a third leg that you look at before you come to the conclusion, one way or the other, whether the person is culpable or otherwise. And that is defenses. You cannot talk about a person's culpability without addressing whether the person is entitled to a defense or to. Indeed, the law tells us somewhere in Act 30 that you have to consider from the story the person is telling or from his posture. Is he mounting a defense? Even if he is not specifically mounting a defense, you would have to examine it to see, the proved set of facts to see if the person is entitled to a defense. And defenses come in several forms, mainly divided into two categories as total or complete defenses which exculpate a person from liability, and the partial defenses which tend to reduce or lessen a person's exposure to the criminal law in terms of the consequences that are visited on a convict. So the former one, that is the partial defenses, will come by way of excuses or some mitigating circumstances. And if you look at 52, 4 of them are spelled out there. Then 52 takes you on an excursus to 53, 54, 55, 56. And in terms of the complete or total defenses, you are looking at mainly between sections 30 to 45. That is where we have justification provisions. And so this is how you look at things in a broad spectrum to arrive at a person's culpability or otherwise. If you don't go through this exercise, then you will not be in the province of the criminal law. So once again, Actus non facit reum nisi mensitria. If you do not remember anything in the criminal law at all, at least this should be at the back of your mind. So you are looking for an Actus reus, you're looking for a mens rea, and you're looking for defenses. How do you determine whether there's a defense there? There's no magic wand. You have to read. So this will end my general intro.
Right. Thank you very much, Honorable Special Prosecutor. And we have benefited. And criminal law, as we know, this is the very critical thing we need to do, because that is the foundation. If you don't have that, you cannot look at the specific offenses. So having listened to him, he will now invite you to maybe make comment or raise questions that you may have. You have to be very brief and straightforward to the point, so that we can use the limited time that he has profitably, as he has to be stepping out for a meeting. So if you want to speak, just raise up your hand and then I'll release you. Okay, so Jaylan, just straightforward to the point. Jaylan, yes.
Yeah, thank you, Doug, and thank you, Honorable Special Prosecutor. Mine is on the offense of stealing by finding. When you look at it, the mens rea is always very difficult to, especially when you don't know the thing belongs to another person. Thank you.
Okay. So it is all in respect of dishonesty. And what amounts to dishonesty? You appropriating something that does not belong to you. That is the baseline. So stealing by finding, you come across an item. The nature of the item, where you found it, the circumstances in which you found it, you can tell that this is not a vacated item. And so you seeking to pocket it for yourself speaks of dishonesty. And if you look at the illustrations therein under Act 29, for instance, the clearest form is where the item has marks on it indicating a person's ownership, for instance, some initials. Or say, you find yourself in a living room with other people, maybe strangers. You're having a chat. You see a phone lying there in the sofa, and then you presume that someone has vacated the item with no intention of coming back for it. That speaks to dishonesty. If you just pick the phone and pocket it, you found it. You found it where? Under what circumstances? What item was it? You get it. So don't go out of the province of the definition of dishonesty. Within the four corners of dishonesty, and based on the illustrations under the Act, you can't tell. I admit that there are some gray areas, But baseline, if the person pocketing the item does not speak of dishonesty, then it is more likely to go. But it is very unlikely in this day and age. If you read cases like Ramuwala and the others, you can tell how the principles were enunciated therein. Foundation of that is dishonesty. If you pick an item like a bona vacancia somewhere that it is unlikely that anyone is coming for them, anyone is looking for them, or you cannot by any reasonable assertion return it to the owner, then you are not being dishonest. But if not, you are being dishonest, and that will amount to stealing. Any more?
Yes, Gag.
I have.
Gag, straightforward to the point. Yes.
Okay, sir. I actually want him to give us the best way to answer.
I have about 4 minutes.
4 minutes. Okay, so 4 minutes. Okay.
Yes, the best way to answer causation question.
Hello?
In relation to that.
12 minutes.
12 minutes. All right. Okay, 12 minutes.
Okay. I mean, the best way to answer a causation question in relation to that, assuming you get an answer.
In relation to what?
Causation.
Did you say in relation to death?
Yes, please. Assuming.
Hello?
Something.
Am I on?
Yes.
Yes. He said in relation to death, how do you address causation aspect? I think if I understood his question.
This is really broad. By any issue or causation starts from 13, and in relation to death, you take it to 64. Sometimes, depending on the way it was brought about, you could also take it to 81. So that is what I can say. Your question is overly broad.
Okay. All right. So
but the provisions on causing death.
Okay. One gentleman, Kofi Prempe, Honorable is saying that the Kaswa boys now charged with murder and conspiracy. Question: why in consideration of their age is placed? I mean, that's the person put in the chat. I don't know if you get the sense of what he's trying to say.
What is it about?
That doc, the Kaswa boys now charged with murder and conspiracy. Question: why in consideration of their age is placed? Please, when you use the chat, let it stand out more clearly, okay?
In consideration of the ages, I mean, when you go to 26, you know this whole concept of capacity to commit crimes about Dolly in Capex or Dolly Capex, and you know our cutoff point in Ghana is 12 years. So anyone below 12 years is incapable of committing a crime. Not that they have committed a crime, but they are not culpable. They are incapable of committing crime. So anyone above 12 years is capable of, comes under the operation of the criminal law. But it is in respect of the consequences attached upon conviction. That is where we will also consider after 12 to before you turn 18, we'll then fix you under the Juvenile Justice Act. But now I'm straight into criminal procedure, so I'll cut it off there.
All right, thank you. I think, Honorable Special Prosecutor, there's another question.
Any more?
Yes. One, his question is that how adequate or otherwise is Act 29, and for that matter, our legal regime on the issues of LGBTI?
Well, Act 29 just criminalizes specific acts. So if you go to 104, it's criminalizing bestiality, having sex with an animal. It's criminalizing consensual sexual conduct in an unnatural way. It is criminalizing non-consensual criminal acts in an unnatural way, and the natural way is only the penis to the vagina. Any other form is unnatural. So whether it be consensual or non-consensual, so far as the penis is not entering the vagina,
Honorable, the penis should be human
somewhere or some other orifice on the person's body.
Okay. Honorable,
of course, I've talked about bestiality. So if it is not a human penis, it's a dog's penis or a horse's penis, that is also unnatural, because it's an animal.
Okay.
But how I want to end it is that does not criminalize a lifestyle.
Okay.
Act 29 does not criminalize a lifestyle. It criminalizes specific sexual acts. So unless you see or you can assume any act of unnatural carnal knowledge, then the law will take interest. But if they are cross-dressers, drag queens, or they subscribe to some form of sexual orientation or the other, since they are not criminalized, the law doesn't criminalize a lifestyle. That does not come under the purview of Act 29, and I some bill before Parliament.
Okay, thank you.
So can I run now?
Gifty Akosa one. Let's take two ladies, Gifty and then Bex and then.
No, what the prof? Please, last question.
Okay, last question.
Last question.
All right, Gifty.
Thank you, Doc. Though it's Gifty, this is Steven speaking, so we are sharing one phone. I was going to
allow the lady because we haven't had any lady speaking. So if she wants,
it is me. I'm speaking through her. It is me rather who raised the hands. I was going to ask that since Honorable has time, we should allow him to flow so that we can get what he has with him with us. Because of his limited.
My time is up. My time is up
anyway, so
he's
leaving now.
We have to get him back again. We have to get him. It is a nice encounter. We have to get him back again.
Okay, so Honorable Special Prosecutor, thank you very much for coming. And as students are indicating, now on Tuesday.
I'll see about it.
Okay, if you can.
I'll see about it. I'll see if I can create.
So thank you very much.
I can create further time at another time.
All right, thank you very much.
Thank you for having me.
All right, thank you very much. Thank you. Okay, so students, we end this session here, and we have another guest lecture in the night. Miss,
and all the best to you all.
Thank you very much. Thank you, Honorable. Thank you very much. God bless. So students, we meet, we'll be giving a new link at 9 p.m. All right, thank you. Bye.